Well, hello there once again, and welcome to the Employment Law Show. John Scholes here, and right beside me, as always, employment lawyer Lior Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. You can always reach out. I'm going to give you that information right off the top here, 1-855-821-5900 for the phone, help@employmentlawyer.ca. You want to send along an email. We'll probably get to a couple of those in the show today. And the website you always want to have within reach is pocketemploymentlawyer.ca. That website is built and covers a lot of the things, most of the things we talk about on the show each week. It's free, it's anonymous, and you have access to what we call the Severance calculator. That has been used by millions, literally millions across the country. It will tell you exactly what it was supposed to tell you, what your severance should be, the proper amount, the real amount. It'll take you about 30 seconds to use that particular tool. And off you go. On the show today, Guide to Handling Workplace Burnout and Stress. One word, Barbados. That might not be the answer, but we're going to get to that here a little later on. Maybe some phone calls from our long-running radio show as well. But, pal, we always start off with the week that was. What do you got?
Barbados. I like that.
I knew you'd agree.
Well, maybe one day we'll air the show there. But great to be back here and great to be talking about employment law and help as many people as possible. I am glad that I have this opportunity to get on here and to educate and tell you about the things you may not have realized, to give you those options that the law provides for you. It really is about options. Oftentimes, the law gives you options, gives you a choice, gives you the ability to force the issue if your employer doesn't do something it's supposed to. And on this show, we talk about all these things, whether it's a constructive dismissal, a human rights violation, being mistreated in the workplace. We'll talk about that a bit later. Maybe you lost your job. You name it, there are answers, there's solutions, there are things that you can do. And on this show, we try to cover all those things to educate you, empower you with that knowledge. And of course, if you want to get together, talk about something personally, privately, we'll give you contact information throughout the show so you can reach out to myself and my team. Whether you're in Ontario, in BC, and Alberta, we've got you covered. But now that we know what we want to do, let me tell you about a situation that came across my desk. Now, John, this person, when he called me, on the face of it, it looked like everything was okay with him. The reason I say that is because he lost his job. Not a pleasant thing, but it appeared that the company paid him what it was supposed to. So let me break this down. This individual had worked for the same company for 5 months. For 5 years. They had offered him on termination because of the restructuring 7 months of severance. 7 months was the right amount for him after 5 years. But here's the caveats that made it very interesting. He had a salary, a base salary of $40,000, but he also earned commissions. And with those commissions, he earned over $80,000. He also had benefits, pension contributions, etc. Well, when the company calculated severance, they only used his base salary. They did not include his commissions. So even though they said we'll pay you for 7 months, it was just 7 months of base salary. And he called me and he wanted to know, of course, is this right? Well, the answer, of course, is it's not right. It's not even close to being right. And the reason for that, your severance has to include all components of your compensation. All of them. Salary, commissions, bonuses, benefits, pension contributions, car allowance, you name it. So it's not just the number of months that the company's offered you. Of course, that's important, but it's also what's included in it. So for him, 7 months of salary was very different than 7 months of total compensation. So yes, he was wrongfully dismissed, and I'm helping him now to get this resolved. But I wanted to remind everyone there, employees, and even employers, your severance, if you lose your job, has to include everything. If you want to know if something should be included, you ask yourself this very simple question. Would I have received it had I continued working? If the answer is yes, I would have, then it has to be included as part of your severance. And if it's not included, well, guess what? Your employer is doing something wrong. You have to call me right away.
In that situation, if you have someone, if this example would be perfect, someone who's owed maybe commissions that are going to be paid in the future, or possibly a bonus that they get every July and they were let go in January. So they got, 7 or 8 months severance coming up. Within that period, had they still been working, they would have received the bonus and commissions. Do you have to think forward and get it because it would be coming up anyway?
Yes, absolutely. Not only do you get whatever you would have gotten moving forward, but if you would have gotten something paid after the period of severance, you have to get a prorated portion of that.
Wow.
So let's say the bonus is paid in December and you were let go in April. Well, wait a second. You have to get a prorated portion of the bonus for the time that you worked. The employer doesn't just get to say, well, you're not going to be here in December, so we're not going to pay you a bonus. So very important to remember all these things. People oftentimes, when it comes to severance, focus on the number of months. Is 3 months enough? Is 18 months enough? And of course, that's always the number one question. But the number two question, equally important, is were all my components of compensation included in that severance? They have to be.
Including stuff like a car allowance, cell phone, all those fringe?
Absolutely. I spoke actually with a gentleman who had not a car allowance, he actually had a company vehicle, that was actually with Tesla, that he had from work. Well, the company wanted the car back when they let him go, which is fine, but they had to pay him an additional amount so he can rent a car over the next number of months. So car allowance, or actually the value of the car that you have, the company car, has to be included. Commissions
make sense for somebody in a sales role, but take someone like a server or a bartender possibly, where it's tips. Tips can do this from week to week, night to night. Looking at severance, if it's a year out or 6 months, how do you figure that out?
Well, that's equally as easy and equally as important, because if you have a compensation that changes week to week, month to month, year to year, we would look at an average. We don't necessarily know what you would have made had you continued working, but we can get a good sense by looking at an average. So if we, let's say, look at a 3-year average, and if your average compensation over that period of time is $55,000 a year, that's the figure we're going to use to calculate your severance. The employer may say, well, no, let's look at a different figure. Wrong. It should be an average.
The website, employmentlawyer.ca, very useful. You can go there anytime. On that website as well, you'll find links to our long-running radio shows. Tune in. You have a chance to call in every week across the country with those shows. We get some phone calls from the show. We play them back here. We talk about them for education, right? We'll get to our first phone call from one of our radio shows right now.
Terminated without cause. There was no severance package. I spoke to the owner of the company and I let him know that he has to pay me for termination pay. He said he's not paying anything until he's ordered to. I went to the labor minutes, but their calculation is absurd.
How long did you work for this company?
4.5 years.
What kind of a job and how old are you?
Driving a truck. I'm 59 years old now.
Absurd seems like the good word, right?
I think that's the right word to use here. And let's be very clear, when it comes to severance, number one, it's not an option for the employer. They don't pay it if they want to, if they feel like it, if they're being generous. They have to pay severance by law. There's no option here. It's not optional at all. Number two thing, equally as important, is the government cannot help you get your full termination entitlements. They can only help you get a tiny fraction of your entitlements, your minimum entitlements. That's why when you contact the government and ask, well, how much severance am I getting? The number that they give you, which is only your minimum entitlements, is a lot less than what you're actually owed. So we have a person here that's worked as a truck driver for a number of years. Company doesn't feel like they have to pay severance. Of course they have to. Question now becomes, well, how much severance? The real amount, not the minimum amounts, the real amount. So I'm going to show you how to calculate that severance so you can do that yourself for your situation. We're going to go to pocketemploymentlawyer.ca and we're going to use our severance calculator tool. And we're going to see exactly how much severance this person is owed. So he's been a truck driver just for under 5 years, 59 years of age. Company says, yeah, no, we don't feel like paying severance. Well, too bad. You see on the screen there that 8 to 9 months is the right amount of severance that he's owed. 8 to 9 months, again, of total compensation. He can get that. I can help do that. And by the way, same with you at home. If you're not getting the severance that you're owed, easy to get it resolved. It starts by giving me a call.
Not uncommon with truck drivers. Their bosses say you're a contractor, and with construction people as well. They all think they don't get severance. We've had that call a billion times on our radio shows.
Well, truck drivers actually have kind of the double whammy, because not only oftentimes do the companies say that you're a contractor, which guess what? You're not a contractor, usually if you're a truck driver. Oftentimes they say, well, you're federally regulated, so we're not going to pay you because it's different. It's not different. And you're not a contractor. And same with construction. Yes, construction employees do get severance. If you had a job and you lost that job, you're owed severance.
Lior, in addition to actually practicing law, which he still does, he also does a lot of radio, TV, of course, like this, and live streaming on LinkedIn and Facebook and YouTube. You want to take part and tune in stlawyers.ca, stlawyers.ca. Let's get to a question from one of your live streams here, pal. It says, I've just been placed on a layoff. My manager said it is largely due to a lack of available work. Though we've never been busier, and I will be recalled when things pick up again, is something I have to accept.
So obviously, this is a situation where the person feels that their employer is not being honest.
Yep.
They're saying, well, you know, lack of work, but there's a lot of work. But here's the thing, it actually doesn't matter. It doesn't matter whether there is a lack of work, or whether the company's lying about that and there's a different reason. The reason for that, the reason why it doesn't matter, is your employer does not have a right to put you on a temporary layoff. Whether it's a good reason, bad reason, no reason, they can't. If you're put on a layoff, you have the option. We started the show by talking about options. One option is you can accept it. Of course, you could sit at home and wait to see what your employer does. Obviously, that's your right, that's your option. But the second option, which may make more sense, is you can consider that temporary layoff as a termination and get your full severance. Good reason or no reason. So it doesn't matter. Even if the company truly is slower, the business is slower, and that's why they put you on a temporary layoff, you still do not have to accept that. You can force the issue and get severance. Of course, if you want to do that, happy to chat.
Let's get into a short break before we continue. Our main topic, as mentioned, is how do you handle burnout and stress in the workplace? We will tackle that after a break. In the meantime, here's that number again to reach out anytime to Lior and his team, 1-855-821-5900, help@employmentlawyer.ca. Lots more of the employment law shows coming up. Stay tuned. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Welcome back to the Employment Law Show. John Scholes here and Lior Samfiru. Of course, as I mentioned, we always tell you the contact information when we come back and when we go out, so you can write it down and keep it. 1-855-821-5900, help@employmentlawyer.ca, or you have the option of pocketemploymentlawyer.ca. That website is free and anonymous as well. All right, guide to handling workplace burnout and stress. Point number one is this, Lior: an employee's performance can be significantly impacted by workplace stress and burnout. Talk about it.
Yeah, it's in workplace stress, workplace burnout. Back when I started practicing law, this wasn't something that was often talked about. It was almost assumed, well, you deal with this. Well, that's no longer the case. An employer also has the interest to ensure that the workplace is running smoothly, that employees are productive and happy. A happy employee is productive. A happy employee wants to stay and continue working. And it's a really big deal, especially these days. We've had to deal with pandemics and many other things that have impacted our lives. So workplace burnout, workplace stress is a real thing. It's a big deal. It's a big issue. And an employer has obligations in that realm. We'll talk a bit about that. But the starting point, the point I really want to make is don't ever feel ashamed because you're dealing with that workplace burnout and stress. It's normal, it's natural, and the law even accepts and understands that. So let's be very honest about that with our employer, with ourselves, with our families, because if we are honest about it and we engage in some of those tactics that I'm going to talk about in a second, we can deal with that. We can alleviate that stress and hopefully go back to having a happy and healthy work environment.
Yeah, number two, you kind of alluded to it, that as employers, they have an obligation, right, to provide a healthy and safe work environment for all their employees.
So the number one obligation an employer always has is to have a healthy work environment and to support their employees in making sure that that work environment is safe and productive. Now, so there's many jobs that the work is always going to be stressful no matter what the employer does. There's deadlines, there's stressors that come up, and it's just part of the job. But an employer has to do what it can to minimize that stress, not to cause undue stress, not to create a situation where the employee is under more stress than they need to be. That means in terms of how they're treated. You can't put extra pressure that's not necessary on an employee. You can't be bullied to an employee. You can't put them down and create that additional stress. Even in terms of the job, the job often is stressful enough, but if there's a way to reduce that stress without hurting the company, an employer has to do that. When an employer doesn't do that, where they create an unnecessarily stressful or poisoned work environment, the law says, well, wait a second, not so fast. That fact may result in a constructive dismissal. If you're being mistreated in the workplace, if your employer is not supporting you in the workplace to make sure that that place is healthy and productive, You may be able to say, by doing that, employer, by not meeting your obligations, it's as if you've terminated my employment. Now you can get your severance as well in that situation. So very important to remember that this issue is something an employer has to address.
Again, this week we're talking about handling workplace stress and burnout. Point number 3 is this: employees experiencing stress or suffering mental illness in the workplace, they can get a doctor's note for accommodation. Yeah?
Absolutely. So if you're dealing with a workplace stress, if you're dealing with a mental health issue, whether it's caused by the workplace or it's unrelated to it, but if it impacts the workplace, your employer has a duty to provide accommodation if possible. That may mean modified duties, modified hours, reducing your hours, allowing you to work from home so that you can get back into a healthy place. And it starts by getting a doctor's note. It's not enough for you to say to your employer, hey, employer, I'm very stressed out, so therefore I want you to let me work from home. If your employer says, fine, that's okay. But the better way to do that, the way that requires your employer to deal with that, is by getting a doctor's note. The doctor's note, by the way, doesn't have to say what your medical condition is. They don't have to say why it is that you need accommodation, just that you need it for medical reasons. And if an employer doesn't do that, we don't care what your doctor says, too bad, you just continue working as ever. Well, no, that's a human rights violation, illegal. Could be a constructive dismissal as well. So a good place to start is with that doctor's note.
It's funny you mentioned working from home, and just to take a break from our 4 and 5 here, is that duty to accommodate threshold's pretty high, right?
Very high, and oftentimes an employer has to accommodate, John, even if it means that it costs the employer money, even if it causes some logistical problems, you still have to do it. Many times, too many times, frankly, an employer I see saying, well, you know what, this is going to cause us some problems if we accommodate you, so we're just not going to go there. We're not going to do that. No. Even if it's hard, you're expected to do that. Of course, there's a point that it becomes so difficult, so costly that, yes, an employer doesn't have to go that far. But that point is a very high point, and oftentimes employers just don't want to go quite that far.
In addition to an accommodation with the support of a doctor and note, as Lior just mentioned, employees are within their rights to go on a leave of absence, right, due to stress and burnout.
Absolutely. So we talked about making your workplace better through accommodation, through modified hours, modified duties. And if that works, that's what you need. Again, your employer has to do that. But sometimes that may not be enough. You need additional support, in this case, being off work, getting time off work to get better, to get healthy, to hopefully get well enough to come back to work the way you were. And again, it starts with that doctor's note. It doesn't have to be being off work. You can be off work for mental health issues. It doesn't have to be because you have a bad back or you broke a bone. Not at all. If your doctor feels that for medical reasons you should be off work, whether it's for a week, for a month, for a year, you can do that. You cannot be punished for that. You cannot be fired because of it. You cannot be threatened and you cannot be refused. As long as you have that doctor's note, you can take that time off, and sometimes that may be the best thing that you can do in order to get healthy and better.
A lot of confusion. We get this from our viewers and our radio audience as well. Lior is saying, well, I get that, but I only have 10 sick days. After that, I'm out of luck.
No, not at all. So sick days is very different than being off work. All sick days means is that there's a certain number of days for which your employer is going to pay you while you're off work. That's very different than being off work. You could be for a month, for a year. You may not get paid for all that time, at least not by your employer, but that's fine. You can apply for disability benefits. If you have them through your benefits plan, you can get some benefits from the government, including EI sickness benefits, but you can be off as long as you need to, so long, of course, as you have your doctor's support.
I think the final point on this one when it comes to stress leave is the fact that the employer, they can't be fired if they need accommodation or they take a stress leave if they're suffering from some sort of medical condition, right?
No. Just like you can't be fired for having a broken bone and being off work because of that, you cannot be fired because you're dealing with workplace stress and it's impacting your health and it's impacting your ability to work. But the key here is this. You need to tell your employer. Because if your employer doesn't know what you're dealing with, they're just thinking you're not doing a good job. They have no idea why. Well, they may let you go. But if they know, wait a second, there's a medical reason, I'm dealing with this issue, it's impacting my health, and maybe even support that with the doctor's note, now all of a sudden, they can't fire you, they can't punish you, they can't do anything to you, so you're protecting your job. So sometimes people think that by telling their employer, they're risking their job. No. By telling your employer, you're protecting your job. You're giving yourself rights that you wouldn't otherwise have. If you're not sure how to do that, if you're afraid, if you've tried and your employer is still giving you a hard time, well, that's when you and I need to speak.
Again, the website employmentlawyer.ca is where you're going to find links to our long-running radio shows across the country. Phone call number 2 from one of our radio shows coming up right now.
I'm calling for my brother. He's 66 years old. He's worked for this company for 21 years. They offered him a buyout, and he had some health concerns going on. So he said, I can't do this, and give me a copy. They wouldn't give him a copy. They just want to sign a piece of paper. He's still dealing with the health conditions. Told him, we want you to sign this new work contract, and we want you to retire, and the buyout's off the table.
They've done everything right.
I don't even know where to start addressing this. I mean, you name all the things that we tell employers not to do. Well, these guys have kind of done it. Well, no. So let's be very clear. First of all, no, he should not be signing a new employment agreement. I guarantee you, I would bet anything I have on this is that one of the things that employment agreement does is it limits his severance so that they can turn around and fire him after he signs that agreement and save tens and tens of thousands of dollars in severance. Very good idea, by the way, never to sign an employment agreement just because your employer wants you to. It's bad news. Second, you cannot be told to retire. There's no mandatory retirement. You cannot be told that you need to retire because of your age or because of a medical condition. Illegal. Can't do that. Even the suggestion that you should, that itself could be illegal. It could be a human rights violation right there. And of course, if you are dealing with a medical condition, as I said, get a doctor's note. You have to be accommodated. And the company, again, has no choice in this matter. So again, yeah, this employer has done everything wrong. The good news is there's laws coming from all kinds of sources that protect this employee. Same with you at home. Your employer won't accommodate you. Your employer is putting pressure on you to retire or to sign an employment agreement. You don't have to. You are protected. And always happy to chat to you about how we actually make sure we enforce those rights.
We'll take a short break. On the other side, do you have to accept a demotion? We will tackle that and drill down on that one after that short break. In the meantime, here's that number again, 1-855-821-5900. You want to send along an email anytime. That is help@employmentlawyer.ca. Lots more coming up. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Alrighty, welcome back. And welcome back to the Employment Law Show. John Scholes here. As always, Lior Samfiru. You can always reach out to Lior. He's got a great team standing by to talk to you on more of a lengthy private conversation if that's what you want. 1-855-821-5900. The email address you can use anytime to type your concerns is help@employmentlawyer.ca. And this website that was put together several years ago, it's a beauty. It pretty much covers everything we talk about on the show, but you can take your own time to digest it, go through all the different topics, and on the other side, you'll have access to what we call the severance calculator to calculate your severance, the real amount. That website is pocketemploymentlawyer.ca. It's absolutely free. It's absolutely anonymous, and millions of your fellow Canadians have used it. So give that a spin when you got some time. Again, pocketemploymentlawyer.ca. Okay, one more phone call from our radio show. Again, employmentlawyer.ca. Media tab. You'll find a station somewhere near you across this country that's going to carry our show weekly, about an hour long. Tune into that as well. Our third phone call for this show, Lior, is coming up right now.
My husband has been employed in IT security. He's had this pretty well the same position for about 12 years. Current employer sort of shifted around his responsibilities, took him out of a managerial role. Recently, they took him out of a Monday to Friday 9 to 5 role, put him on a rotating shift work.
Okay.
So this, hopefully, for our regular viewers, screams constructive dismissal. It should scream it. And the reason for that is, number one, demotion. Anytime you're demoted, in this case appears to be a true demotion. You used to be a manager, now you're not a manager. Well, other than the fact that it may mean less money, but it also is embarrassing. How do you show up for work when everyone used to be the guy, the manager, and now they've taken that away? What have you done wrong? And how can you continue facing your colleagues? And the law understands that you shouldn't have to continue working in that situation. By being demoted, you may have the option to treat that as a constructive dismissal, as a termination, and get your full severance. So that's the one aspect of constructive dismissal. The second one here in this call that we had is the fact that the schedule changed. He used to work regular 9-to-5 schedule. Now he's working rotating schedules. No, that's a huge change. We're going from regular business hour type of schedule to rotating schedules. Huge deal. It's going to change your life. It's going to change how you work. And the law says if you're ever faced with that change, you don't have to accept it. You can treat that as a termination. So we have constructive dismissal here in the most obvious way. So now that we know that, of course, the question becomes, yeah, this is a constructive dismissal, but how much is he owed? What are his rights here? How much severance should he get? Well, we've talked about it. We mentioned it before. We're going to try it one more time. We're going to use our severance calculator tool, which, of course, you can find at pocketemploymentlawyer.ca. And let's see how much severance we get here, how much severance this person gets because he was constructively dismissed. So he works in IT security. We know he's been there for about 12 years. Say he's 45 years old. Company hasn't offered severance because they're saying, we're just going to demote you. Well, no. You can see on the screen there, he's owed up to 18 months severance, somewhere between 16 potentially to 18 months of severance. And this is done without the company letting him go. This is without the company firing him. This is just because it's a constructive dismissal. So at home as well, if you think you've been constructively dismissed, you can find out how much you're owed. And of course, at pocketemploymentlawyer.ca, we actually have a tool that allows you to find out if your situation is in fact a constructive dismissal.
Let me ask you this particular person, demoted and also a shift change, those individually stand alone would be enough for constructive dismissal, right? He doesn't need the double shot.
He doesn't. That just makes it that much more obvious. But each one of them on their own would be a constructive dismissal. A demotion, big deal. Change in shifts like that, huge deal. Either one is a constructive dismissal.
Let's get to a quick note from terminationquestions.com. Yet another website you can use, terminationquestions.com, says, I've just been told that I must submit to a performance review and potential probation due to a baseless customer complaint. Do I have to go along with this whole process?
Well, it's okay to go along with the process. You're not going to tell your employer, too bad, I'm not going to do it, I'm not going to do what you're telling me. You don't want that to become an insubordination situation. But what you want to do instead is, if you think that the complaint is baseless, if you think you've done nothing wrong, at the same time, I want you to say so, and in writing, of course. Tell your employer, here's what actually happened. Here's why what that customer says is not correct. And by the way, here's the people you can talk to corroborate what I'm telling you. You know, Barbara was there and Joey was there, whatever it is. Tell them all the information that they need to know so that it's there, it's on the record. But if they say, well, we still want you to undergo this training or this performance process, do it. You don't want to give them an excuse to say you were refusing, so that gives us grounds to let you go. But by telling them what actually happened in writing, you're protecting your job. You're going to make it almost impossible for the company to let you go for cause. But again, in subordination, I would avoid that.
This whole thing about this person obviously has a job. This being put on probation while you're already an employee. Sounds a little weird.
We talked about that recently on a radio show, John, and the reality is that it's meaningless. If you've already worked more than 3 months and the company puts you, quote unquote, on probation, it doesn't do anything. It doesn't give the company new rights. If it makes them happy to say, that's fine, but it doesn't actually mean anything. So don't freak out about it. As a practical matter, you can only be on probation for the first 3 months of employment, and that's it.
And that's without getting paid if they still choose for the 3 months. After that, you're getting severance if they even try 6 months, right?
Exactly, or 8, or any other amounts. Frankly, if it's 3 months and a day, you're going to get severance. And even probation is not automatic. It has to be part of an employment agreement.
Again, that came from terminationquestions.com. You can use that any time, and I'll give you the rest of the contact information now that we are wrapping up for another show. The phone number, as always, 1-855-821-5900. The email is help@employmentlawyer.ca. And that other website, always go there just to casually peruse through. That's pocketemploymentlawyer.ca. It's free, it's anonymous, and you'll have access to the severance calculator as well. Again, pocketemploymentlawyer.ca. Thank you so much for tuning in. We'll catch you next time on the Employment Law Show.